This is Bloomberg Law with June Grasso from Bloomberg Radio.
Officials in Fulton County, Georgia, are vowing to fight a recent FBI raid where agents seized more than 700 boxes of ballots, voter rolls, ballot images, and other election records from the 2020 presidential election. Jeff Duncan, who was the Republican lieutenant governor at that time, says there were multiple audits, hand counts, and verifications of the election results.
We've spent nearly 6 years debunking every conspiracy theory. There's been not even a single page of proof that there's been any sort of fraud involved. This is another somewhat predictable act by Donald Trump.
The Justice Department seized the records as part of a criminal investigation using a grand jury subpoena. The Trump administration has been stepping up efforts to obtain sensitive voter information from states, not only names and addresses, but voter birth dates, driver's license information, and partial Social Security numbers. The Justice Department has sued 24 states and Washington, D.C. for refusing to turn over voter data. And federal judges have started to weigh in, delivering early losses to the Trump administration in lawsuits against state leaders in California and Oregon. My guest is Rebecca Green, a professor at William & Mary Law School and director of their election law program. Rebecca, will you remind us how Fulton County, Georgia was sort of like ground zero for President Trump's unsubstantiated claims of voter fraud in the 2020 presidential election?
Yeah, so there were several jurisdictions around the country where the president, then candidate Trump, sort of went hard on the theory that there had been massive fraud. And so he was able to convince lots of people that those elections needed to be investigated carefully. And, that's sort of why those jurisdictions came under scrutiny. And so Fulton County was one of those jurisdictions. And there has really been sort of a relentless push, both after the 2020 election and then continuing to today as we see. But, your listeners will remember the infamous call that President Trump made to the director of Georgia's elections, Brad Raffensperger, where he asked him to find 11,000 votes for him. So this has been ongoing, this focus on Fulton County particularly.
I mean, there was a machine count and 2 recounts that confirmed the results in Fulton County, Georgia. So the due diligence was done.
Yes, so the focus on Fulton County and other jurisdictions around the country, especially in places like Arizona, resulted in sort of very careful review of all ballots, of voting machines, sort of every aspect of the election. They've been under intense scrutiny for years because of these pressures, and there's been no finding of any issues, particularly no finding of widespread fraud that would have changed the result.
So the FBI seized hundreds of boxes of ballots, voter rolls, ballot images, and other election records. And the search warrant said it was about potential voter intimidation and election interference. I mean, have you ever heard of another case where they seized that kind of evidence? They seized the actual voter rolls?
Boy, I can't think of an example. That doesn't mean that it hasn't happened. There certainly has been, a lot of criminal investigation, of our elections over the course of U.S. history. But I can't think of an instance where the federal government has seized voting equipment. I could be wrong about that, but nothing springs to mind.
The election interference claims, as you described, they have already been litigated over and over again.
Yes, that's correct. So I'm assuming, I'm not a criminal law expert, but I'm assuming that in order to get a warrant to seize this equipment, there must have been evidence that convinced a judge that there was a crime that hasn't been sort of settled in the courts already.
I believe there'd have to be some kind of finding of probable cause at least. What's the danger with the federal government seizing these voter rolls?
Well, in the instance of the federal government obtaining this material, there are layers of concern that people have voiced. So there is lots of concern about voter privacy, for example. There's concern about this being sort of a precursor to future efforts to take equipment out of state custody, equipment and ballots out of state custody, in future elections. So there's all kinds of concerns that have been raised about this activity as being sort of more than a run-of-the-mill sort of criminal investigation.
So Tulsi Gabbard, Director of National Intelligence, was there, and she's been in charge of an investigation into election integrity, so-called election integrity. And at one point, Trump asked her in a cabinet meeting whether she had found evidence in burn bags of how corrupt the 2020 election was. And she said, we're finding documents literally tucked away in the back of safes and random offices in these bags and in other areas. It sounds sort of like, Rudy Giuliani's talking about, votes being found in suitcases.
Yeah, there's been lots of rhetoric, but so far in courts of law where, judges have required plaintiffs to bring that evidence forward, there hasn't been any credible evidence so far, brought into courts. So, you can scream from the rooftop that, there's been fraud, and you can get on the airwaves and make all the allegations that you want. But ultimately, it's courts of law that have to review that type of evidence.
And the Justice Department is looking to get voter rolls from something like half the states that's in litigation. They say they want the voter rolls to protect the election integrity. I mean, what would be a reason for them wanting the voter rolls from every state?
Well, I suspect that there's an effort to determine whether there are people on the voter rolls who shouldn't be there, and to sort of leverage the power of the federal government to examine that material. But I think it's important to note that federal law requires that states actively vet their voter rolls. There are very sort of careful processes that every state is required to go through to make sure that ineligible voters are not on their voter rolls, and to clean them up periodically to make sure that, as people move, as people pass away, that the voter rolls reflect that, to identify double voting, all these kinds of things. So states already go through very rigorous procedures to make sure that their voter rolls are as accurate as possible. And I think it's worth saying, obviously that's a very Herculean task because, Americans move quite frequently. There are constant sort of turnover in terms of who should be and who shouldn't be on the rolls. So it's an ongoing effort, but that's the job of state election administrators, and they take it very seriously.
Explain state versus federal as far as their roles in elections.
Sure. So Article 1, Section 4 of the United States Constitution grants states the authority to make rules involving the time, place, and manner of elections. So that's a very clear federal constitutional grant of power to the states. There is a next phrase right after that says that Congress can make rules governing the time, place, or manner of elections also. So there's this sort of way that the federal government can sort of take over elections if it wants. But the grant of power to the federal government is to Congress, not to the executive. And so the feeling is that unless Congress acts to take the power away from states to manage their voter rolls, that the executive branch has no role in doing so.
Yesterday, President Trump suggested on a conservative podcast that Republican state officials should take over and nationalize elections in 15 states to protect the party from being voted out of office. That would violate the Constitution, wouldn't it?
Yes. So as I just described, the U.S. Constitution delegates to states power over elections. So there would be no ability for a political party or sort of by executive command for the federal takeover of elections. So that's sort of a first point. And I think a second point that's really important to make here is to underscore that there are tons of protections within state law that ensure that partisans, that is Republicans and Democrats, members of the two major parties, are present and able to sort of weigh in and hold accountable elections at every level. So this is from boards of elections that are populated with Republicans and Democrats, all the way down to partisan poll observers, where Republicans and Democrats sort of are authorized to watch every aspect of elections, from authorizing voting machines right up until you're counting the ballots. And so there already is a huge amount of what I call adversarial oversight of the election process to make sure that one party is not able to sort of do anything fraudulent or in secret without the other party sort of being privy and present. So those kinds of adversarial protections are very much part of our election process and should provide some comfort for anyone who's concerned about either Republicans or Democrats sort of taking over. In other words, elections are bipartisan efforts at every level.
And he is repeating the claim that immigrants are voting illegally. Is that prevalent? Does it happen?
Oh, it certainly happens in the sense that when I've seen sort of reports on this, it's usually somebody who mistakenly believes that they are allowed to vote. So, for example, they get a driver's license and they're asked, do you want to, register to vote? They don't understand what that means. They mistakenly get put on the rolls, this kind of thing. But I think, common sense dictates the reality that if you are in this country illegally, the last thing you want to do is, do something illegal, that is register to vote and sort of push yourself out there. I mean, people who in this country who are here illegally, are not, I think it's safe to say, coming out in droves to register themselves with state governments. So I think, the idea that there are massive numbers of non-citizens voting in our elections, it sort of defies credulity for that reason.
Thanks so much for an interesting conversation, Rebecca. That's Professor Rebecca Green of William & Mary Law School. Coming up next on the Bloomberg Law Show, Tom Goldstein, once a legal superstar, is on trial for tax evasion. And his double life as a high-stakes poker player is at the heart of the charges. I'm June Grasso, and you're listening to Bloomberg. Tom Goldstein was known as a superstar lawyer. In fact, a superstar Supreme Court litigator who argued 45 cases before the High Court. He also co-founded the most prominent blog covering the court, appropriately called SCOTUS Blog. That's why it came as a shock to the legal establishment when Goldstein was indicted last January for scheming to evade taxes and using millions of dollars from his law firm to cover gambling debts. According to the indictment, Goldstein was living a double life with a side career as a high-stakes poker player. Very high stakes, winning more than $50 million in a series of poker matches in 2016 to fund a lavish lifestyle. Now Goldstein is putting his cards on the table in court, where again the stakes are very high. He's facing prison time if convicted. My guest is Holly Barker, a senior reporter for Bloomberg Law who's covering the Goldstein trial. So Holly, tell us about Tom Goldstein.
So Tom Goldstein, I think, is best described as a legal nerd celebrity. He co-founded SCOTUSblog.com, which was this groundbreaking online resource on the Supreme Court back in 2002. It was a big deal, particularly at the time, because the Supreme Court's website, if it had one, was in its nascency and it just wasn't terribly accessible. He also cultivated a career as a really high-profile Supreme Court advocate. He argued dozens of cases before the High Court. And what makes that even more impressive is that, unlike many of those who can make the same claim, he didn't go to an elite law school or clerk for a justice. He instead hustled his way into the career by identifying circuit splits and cold calling parties to offer his representation. So he's sort of this unlikely Supreme Court star and is very well known in legal circles, especially in Washington, D.C.
And talking about unlikely, tell us about the reaction when he was indicted.
People were shocked. So he was indicted in January 2025, and he was initially facing 22 counts, mostly tax charges. The government moved to dismiss 6 of them on the eve of trial. So now he's facing 1 count of tax evasion for 2016, 8 counts of aiding and assisting in the preparation of false tax returns, and that's for 2017 through 2021. 4 counts of willful failure to pay taxes for 2017, 2019, 2020, and 2021, and 3 counts of making a false statement on a loan application. So for the tax evasion count, the government's advancing 8 theories of alleged quote unquote acts of evasion. They include using his law firm funds to pay personal gambling debts, so mischaracterizing personal expenses as business expenses, providing false and incomplete information to his accounting firm, making false and misleading statements to an IRS revenue officer, transferring at least $960,000 in personal funds to his firm's trust account to shield the funds from IRS collection, allegedly, and to use foreign individuals and bank accounts to receive income. For the fraudulent tax return charges, those are based on particular line items on his tax returns that prosecutors say are false, like gross receipts, other income, so forth. And the willful failure to pay counts are based on his alleged failure to pay his taxes on the date that they were due. So he filed a tax return, got an extension, eventually paid the taxes with penalties and interest, but the government's theory is that he had the money available to pay the taxes when they were due, but instead elected to fund this ultra high stakes gambling and ultra luxury lifestyle. And I think that's sort of where the real shock to the public came was sort of, there had been some media coverage of Goldstein's gambling in the past. So people were sort of aware of it. But I don't think that the public sort of had a sense of how serious of a gambler he was, or that he was playing multi-million-dollar hands. There were also allegations that his defense team was able to get excluded about paramours, women he was having relationships with, that he allegedly had on the firm's payroll, but all of that got tossed. I think it was shocking to see such a high-profile sort of legal hero be accused of such serious crimes. Again, these are allegations, right? But it's quite a fall from grace even to be indicted on charges like that. So people were shocked.
The amount of money on the table in these poker games is sort of astonishing. And the people that he was playing with, high rollers and movie stars like Tobey Maguire, very far from the legal world.
It's mind-boggling. He really was sort of living a parallel life.
During the opening statements, the prosecution and defense painted two very different pictures, basically two stories of what the case is about.
That's right. So the government is painting a picture of this, cunning, smart, charming, very capable Supreme Court lawyer who used his wiles to try to win tons of money gambling, wasn't always very good at it, and, was intentionally trying to get around his taxes in order to keep funding this lifestyle. That's the thrust of the government's case. So his defense, and to be clear, he hasn't put on his case yet, but it's still the government's case in chief. Still, he teed up his defenses at opening and has managed to tease some of it out in cross-examination. So the themes and the defenses include, one, a botched and incomplete government investigation. So he claims this whole investigation was driven by prosecutors and agents who were afflicted by tunnel vision. They sort of decided he was guilty and were only hunting for facts and evidence that substantiated that view. The government keeps claiming that he failed to report significant gambling winnings, but the defense has shown through cross-examination that he didn't always keep what he won and was often playing with other people's money. Tom Goldstein is not a billionaire. He was playing billionaires. In order to do that, he often had financial backers, like investors who had stakes in the game. So, he may have won $50 million playing heads-up poker, but that doesn't mean he took home $50 million. And the government has a picture, and they stipulated to sort of what some of those gambling wins and losses were. But they've done a pretty good job of suggesting that the government just doesn't have a complete picture. And in mischaracterized transactions and allegedly false entries on tax returns, he basically claims that he was relying on his firm managers and the expertise of outside accountants and tax preparers. They weren't asking the right questions. They were making assumptions when they shouldn't have, and so forth. He's also been playing up the complexity of the tax laws and reporting gambling income in particular, and challenging the element of willfulness, which is a heightened intent standard that's in play for tax charges. So, while the prosecution has made a lot of Goldstein's smarts and status as an elite lawyer, again, the defense has done a good job of eliciting testimony sort of supporting his claim and his theme that he just wasn't tuned into the firm finances. Like, yes, he was very detailed oriented when it came to the practice of law, but much less so in management of it. And then finally, for the willful to pay charges, the thrust of his argument is, look, like I filed bank returns, I got the necessary extensions, I entered into a payment plan. Like, how was I supposed to know I could go to jail for this? The idea is, lots of people don't pay their taxes on time and they don't get indicted for it. Instead it's handled with interest and penalties.
That's an argument that I think would appeal to a lot of people. especially those who may have filed late once or twice. And tell us about the IRS agent who had audited Goldstein in 2012, who testified that he told Goldstein's then accountant and power of attorney that he needed to keep better records of his gambling wins and losses.
That's right. So they've had a couple of IRS agents, revenue agents testify, and one of them testified about an audit that predates all of this. And, at the end of that audit, which, by the way, he wound up getting a refund. So the IRS paid him money at the end of the audit. But, he had a proxy dealing with the IRS directly. But the IRS agent said that he told his proxy, his accountant, his power of attorney, that is, that he needed to keep more robust gambling records. He needed to keep a more complete ledger, was basically the thrust of it. But, the defense made the point, the IRS agent didn't say that directly to Goldstein. And when the accountant testified, he's like, I'm assuming that I relayed that to Goldstein, but he doesn't have like a specific memory of it. He's just assuming he did because that's what he did as a matter of course. The other thing that he said was basically that, Goldstein terminated him at the end of that audit. And it was basically Goldstein wasn't happy that he'd wound up in an audit and was upset with him, the accountant, for not having asked more follow-up questions because Goldstein had mentioned gambling to him. So that sort of helps his case or his argument that, look, like I was relying on outside experts.
If the theory is that he wasn't a great poker player, then why were people investing in his poker playing?
Good question. So apparently he was pretty good at heads-up poker, not as good at something that's called a ring match. So a heads-up game is two players, just one-on-one. A ring game is more than two. I guess he was better at one than the other and good enough that people, at least in the heads-up games, were willing to invest in him. And, he won a lot. He wound up, it looks like, perhaps losing more often in years after 2016, but 2016 was definitely a big year for him. Evidence at trial shows that he won around $26 million, I think it's $26.4 million, from Alex Flores, who's a billionaire. So he was good enough, He was described by professional poker players as, I think the word aggressive came up more than once, like multiple people described him as aggressive, and another witness described him as sort of a crazy man. And, I guess maybe that works sometimes and sometimes it doesn't.
Spider-Man star Tobey Maguire took the stand. Tell us how he fit in here.
So Tobey Maguire hired Goldstein to help him recover part of a very significant gambling debt from Andy Beal, who is a Texas billionaire. Tobey had played him, won a bunch of money. Mr. Beal didn't want to pay up. So Maguire hires Goldstein to help him get his money back. And ultimately, Goldstein gets a successful result for him. And, Beal pays up everything that he owes. And then Goldstein gets a $500,000 fee.
Hold that thought, Holly. Coming up next on the Bloomberg Law Show, I'll continue this conversation with Holly Barker. We'll find out more about Tobey Maguire's testimony and the jury's reaction to having a movie star in the courtroom. We've been talking about the trial of Tom Goldstein, once a legal superstar at the Supreme Court, who led a double life as a high-stakes poker player with a lavish lifestyle. The government alleges that Goldstein deliberately failed to tell his accountants about $26 million in poker winnings and repeatedly opted not to pay his taxes on time. While the defense says the evidence will show that Goldstein did tell his accountants about the winnings and that the lifestyle evidence is just a distraction. The trial is offering a colorful glimpse into the world of ultra-high-stakes poker. Spider-Man star Tobey Maguire testified knowing Goldstein from poker circles. Watching all the testimony is Holly Barker, Bloomberg Law senior reporter. Holly, tell us about Tobey Maguire's testimony.
So Tobey Maguire was called to testify in connection with a legal fee that he was owed to Goldstein, but that Goldstein asked him to instead wire to a real estate mogul named Bob Safai. Goldstein had played Bob Safai and lost a significant amount of money and actually had a payment plan. And he had Maguire, direct his $500,000 fee to suffice in order to satisfy part of that poker debt. And the idea was that that income should have been reported as income to Goldstein's law firm, but by having McGuire send this directly to, a poker buddy he owed money to, he sort of avoided having to report it as income, and that was the gist of it. And the matter that Goldstein was representing him in, and McGuire and Goldstein had met one another in poker circles. And McGuire hired Goldstein because he wanted to collect a $7.8 billion gambling debt from Texas billionaire Andy Beal. And Goldstein did it and was successful in collecting that.
And was the jury sort of starstruck when McGuire testified?
Not at all. Or at least if they were, they didn't show it. They treated him just like they treated every other witness. The same level of engagement, same expressions on their face. It wasn't quite as exciting as I think people may have expected it would be. He wasn't on the stand for very long. His, testimony was fairly clean. He looked at ease. He was pretty smiley. I think a lot of witnesses, when they get on the stand, tend to do that if they get a little bit nervous.
He is or was a huge poker player, right? Millions and millions and millions of dollars. When
he left that courtroom, I was left with the impression that he might make more money gambling than he makes playing Spider-Man.
So he's still gambling.
Sounds like it.
Tell us about this bag of cash that prosecutors wanted to introduce, but the judge would not let them.
Yeah, the allegation is in the indictment, and there's been lots of testimony about it. Goldstein brought close to $1 million in cash when he was returning from a trip from Asia. And he was going through Dulles International Airport, and, prosecutors claimed that when he was talking to the agent, he said, the money was gambling. And this is to a Customs and Border Patrol agent. But then when he talked to an IRS agent later, he said it was a loan. But then when he was talking to a firm manager, he said it was legal fees. So they're basically saying that this was income that he didn't properly characterize. And they had hoped, this wasn't before the jury, this was, a discussion that was held outside of the presence of the jury, but they wanted to bring like a representative bag of cash in during the Customs and Border Patrol agent's testimony. And the judge just said, but, we don't see what the probative value of that is. It's not even the same bag of cash. It's not even the same bag. I think it's pretty clear that the prosecution wanted it for effect, but it did not get it.
And how do you even bring that much money through customs?
Apparently it's a thing. They have cash counters and you spend a little time and the whole thing.
Really? How is the prosecution's case going? It seems like the defense has been able to make some of their points through cross-examination.
That's a really good question. I'm still, frankly, trying to digest the case in chief. The prosecution has a goal of resting on Thursday. I think it's much more likely that their case in chief goes into Friday. They've had 23 witnesses to date. We don't have a full sense of who the remaining witnesses are, but we know at least two of them are going to be two of the outside accountants. And I think their testimony is going to be a very big deal because they're going to be able to speak sort of directly to what their interactions with Goldstein were sort of around tax preparation. But to answer your question, the jurors, I think, are going to have a really difficult time parsing all of this. And I think it's less about the facts of the transaction, did these transactions occur? Were they mischaracterized? That sort of thing. And more about what was in Goldstein's mind. And that is really what the jurors are going to have to contend with. And I do think that the prosecution has done a very good job of, teasing out spaces for doubt wherever they are. I think the government spent a lot of time investigating this case, but I think the defense is really going to hold them to their burden.
They have to show that he had intent.
Yes. So there are mortgage fraud charges. Those are a little more straightforward, but the tax charges require a heightened intent standard that the government has to prove that he intentionally violated a known legal duty. So mistaken negligence is not enough to carry the day on tax charges. So if the defense can plant enough of a seed of doubt about whether or not Goldstein intended to screw this stuff up, one of the things the defense said in their opening was This is a handful of mischaracterized transactions in a sea of transactions over, many years. And to sort of cherry pick those and conclude that he was up to no good is a reach. That's sort of another theme of their defense. I don't think the prosecutors have this in the bag, notwithstanding a sweeping indictment. So we'll see.
Finally, is there any hint as to whether Goldstein might take the stand?
I honestly have.
Obviously he's well-spoken, but cross-examination
is
hard for everyone.
Yeah, I'm sure part of him is dying too. I would imagine a lot of criminal defendants want to be heard, but it's that risk of cross-examination that keeps them from doing it. I'm sure that the jurors would like to hear from him. I think in these cases that turn so heavily on what was in a defendant's mind, I think jurors are always hungry to hear from them. Yeah. But we'll see.
Well, you know what they say, when the defendant takes the stand, then everything becomes about the defendant's testimony and whether the jury believes him or her. So high stakes there as well. Thanks so much, Holly. That's Bloomberg Law senior reporter Holly Barker. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.